Friends, on behalf of Heartland Hospice Moose Jaw, I want to welcome you to this advanced care planning seminar entitled Nuts and Bolts, Healthcare Directives and Power of Attorney. My name is Della Ferguson, and I am the secretary for the board of Heartland Hospice, as well as the chair of the Supportive Care Committee for Heartland Hospice. And we want to honor the fact that you are here and that you're open to having what I like to call crucial conversation. It takes a lot of courage, and we honor that courage today. We at Heartland Hospice believe in the value of advanced care planning and its value in supporting end of life. One of our mantras at Heartland Hospice is, we cannot change the outcome, but we can affect the journey. And we believe that advanced care planning can affect the journey. So thank you for being here. Before I begin this session, I want to acknowledge that we are on traditional lands referred to as the Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, Lakota, and on the homeland of the Métis Nation. We respect and honor the treaties that were made on all territories. We acknowledge the harms and mistakes of the past, and we are committed to move forward in partnership with Indigenous nations in the spirit of reconciliation and collaboration. Today, we're going to have a number of perspectives being shared. Our first and main speaker today is Idowu Adetogun. Following her presentation, we're going to hear from Dr. Kerri Hetherington and from Donna Ackerman. All three are members of our Heartland Hospice team, and we are so honored to have such a beautiful set of people willing to share today. And they're going to share different perspectives on the value of advanced care planning. And as I said, we're going to end with a question and answer time. So to begin, I am honored to introduce Idowu Adetogun. Idowu is a lawyer with over 25 years of experience. She's a partner at Grayson and Company law firm in Moose Jaw. She maintains a general practice, and her areas of practice include wills, healthcare directives, power of attorney, and estates. She's also a mediator, and we're honored to have her as a valued member of our team, and equally honored to have her share with us today on such a vital topic. Idy?
Thank you very much, Della, and thank you very much for everyone joining. Again, my name is Idowu Adetogun. As Della said, I'm a partner at Grayson and Company law firm, and we're going to be talking today about nuts and bolts, healthcare directives, and power of attorney. Next slide, please. Healthcare directives and power of attorney are those important documents that are necessary as we advance in age, given the fact that we all know that life kind of throws stuff at us unexpectedly, and it's important for us to be prepared. The healthcare directives is governed in Saskatchewan by the Healthcare Directives and Substitute Healthcare Decision Maker Act 2015. Anyone over the age of 16 years and older who has mental capacity can draft or have someone draft a healthcare directive for them. The directive becomes effective when the maker becomes incapacitated. And what happens is, once you draft it, you necessarily don't have to do anything with it. Just let the person you appoint, who is known as the proxy, know that you have an healthcare directive and you've appointed such person as your proxy. I always advise my clients that it's important to discuss with this person or people before you appoint them. Some people really don't want to do it. Not that they don't love you or they don't want to help you, but some people believe that it's too much of work for them to do. And sometimes emotions are involved, and some people are not equipped to handle such emotion. So the healthcare directive, like I said, it terminates once you have your mental capacity. Next slide, please. Okay. The effect of an healthcare directive is that it is clear and it gives direction. Clear in the sense that you have an idea what you want in terms of if I become incapacitated or if I'm no longer able to take care of myself, these are the decisions I want to be made. And once, if it is clear, it becomes very easy for your proxy to assist you. If it is unclear, then the problem we're going to have is that your proxy will be acting on an assumption of what your proxy think would be best for you. For example, you don't want to be placed on a ventilator when it comes to a point where you are at that point, you are in a vegetative situation. You just want pain medication to be administered. You have to ensure that it is clear. If it is not clear, your proxy can decide, well, you know what, I think I want this person on ventilator, or I think I want this person to be kept alive just because they love you, probably, I mean, if they're members of your family. Requirement, an healthcare directive has to be in writing. It has to be signed either by a lawyer or you have two witnesses who are not lawyers. Verbal healthcare directive is ineffective. So that's the reason why sometimes we have people drafted, come to our office, provide instruction to a lawyer to prepare a healthcare directive. Or I know that when you go into a hospital or a care facility, if you don't have a healthcare directive that is drafted, you ought to be given one, especially if you're going on, I mean, if you're going into operation or if in certain circumstances. So verbal agreement is not effective, neither is it valid. Revocation. You can revoke your healthcare directive either orally, in writing, destroying the directive, or making a new one. Orally is the least of my favorites because then it doesn't, there is nothing in place to show that it's been revoked. And especially if you have provided a copy to your family physician or you've provided a copy to your healthcare worker, verbally revoking would not be effective against that unless you revoke in writing and your healthcare provider has a copy of that document revoking the former document. Or if you destroy it and then you contact your healthcare giver to destroy the document. Next slide, please. Okay. Revocation also. A revocation by a spouse means revocation in the case of a spouse as a proxy, once the marriage is dissolved, if you appoint your spouse as your proxy, once the marriage is dissolved by a decree, it is revoked. So if, say, I prepared a healthcare directive last year, appoint my husband as my proxy, and then by the end of January this year, we separated. If you have not revoked it, there is no decree of divorce, you're just separated, your spouse continues to be your proxy. The only time that is removed as he or she is removed as your proxy is where you revoke in writing or you destroy it and then you inform your caregiver. However, if a court order is issued, if we're divorced and we receive a certificate of divorce, then it automatically revokes. So if you have a situation where you're not separate, you're not divorced, there is no court order, it is always advisable that if you're separated, that you revoke your healthcare directive removing your spouse. Now, who can you appoint as your proxies? You can appoint an adult. The adult must have mental capacity, or a married minor, age 16, who has mental capacity. So if in Saskatchewan, a 16-year-old with the consent of the parent can get married. So if you're married, if you have a 16-year-old who is married, the 16-year-old can be appointed by the spouse as their proxy, as long as that 16-year-old has mental capacity. If you appoint somebody who is 18 and above, the person has to have mental capacity. Next slide, please. The appointment. So when you appoint a proxy, the proxy is required to act in your best interest. When you make an healthcare directive, you're giving instruction to your proxy to act in the manner that you have indicated. So they're required by law to act according to your wishes. They have to act in your best interest. But like I said previously, if they have no knowledge of your wishes, they will be making decisions on your behalf, which they believe is in your best interest. We've had situations where there is a mother or a father all of a sudden becomes sick. The father wants the mother to remain on ventilator. The children don't want that. We've had instances where claims are made to the court. I'm sure that maybe some of you may have heard that or you've watched that in the movies. It's something that happens in real life. The husband, because of the emotion, the relationship, the love. The children, not so much that they don't love the children, their mother, they come from the angle of, I love my mother, but I don't want to continue to see my mother in pain. So if you don't want this situation, you have to ensure that your wishes are in writing and clear. And then the proxy, if you appoint one proxy, the proxy would act as your proxy. But if you appoint one or more proxies, they can act jointly, they can act severally. Jointly meaning that they have to both make that decision. Severally means that either of them can make the decision. So when your directive is provided to a healthcare provider, what the healthcare provider is trying to say is who is acting, how many people are acting, how you're acting, okay? So that when they need to ask questions pertinent to your care, they know who to ask or how to go about that. You can appoint your relatives, you can appoint your friends, but you have to ensure that you appoint somebody that you trust. You appoint somebody that you know is in a position to comply with your wishes. And like I said before, and I will say it again, you want to discuss with them prior to appointing them, because it may not be something that they want to do. When you appoint a proxy, the law does not allow delegation of authority. So if you appoint your spouse as your proxy, your spouse cannot delegate the authority. Your spouse will be the proxy until it is revoked. Next slide. A substitute healthcare directive can be appointed for a day-to-day treatment where someone does not have a healthcare directive in place and all of a sudden something happens. Say someone suffers stroke, or you have or health issues such that you don't have capacity at that time to make a decision. The law allows that a substitute healthcare provider, a substitute healthcare directive be made on your behalf by your care provider or somebody who is close to you. Day-to-day treatment, your proxy can also make decisions regarding your day-to-day treatment. What is required, what should be administered, what you do not wish to be administered. Then we go to admission. When you're admitted in a healthcare facility, your proxy, if you have one appointed, or a nearest relative, if you don't have one appointed, would make that decision on your behalf. If you're in a long-term facility, these are the people that would make decision on your behalf if you don't have an healthcare directive in place. Your personal guardian. There are instances where some people have personal guardian appointed under the Guardianship Act. Or if you don't have a guardian, then we go to your proxy. If you don't have a proxy appointed under your healthcare directive, then the next person is your nearest relative or two treatment providers in the order of priority. Next slide. Your personal health information, the law allows, though the law requires that where you have a proxy appointed, your healthcare provider is required to provide your personal health information to your proxy. And the reason being that we know we all talk about HIPAA and confidentiality and so on and so forth. But irrespective of the act or irrespective of confidentiality, your proxy is entitled to personal health information in order to make informed decision. Then the decision of your personal guardian and your proxy. If the directive is clear, then they have to comply with it. If your directive is not clear, then the proxy makes a decision, and the decision of your proxy is more acceptable over that of your personal guardian, where the instruction is not clear. In instances, I've talked about court application where your healthcare provider is unable to determine what your instructions are, or your proxy is not able to determine what your proxy is, or if there is a dispute between your proxy because your instructions are not clear and your personal guardian and your relatives, applications are made to the court to to obtain a court order. That most of the time is not advisable because you are giving your power to a judge who does not know you to make a decision that would affect you and your family. Then there are instances where some people would say, well, I have a power of attorney. I think that is just sufficient. The power of attorney does not have authority to be your proxy. However, there are some power of attorney documents that are prepared, which we have done also, where we say, where you appoint your power of attorney as your proxy, but it has to be stated in clear language. I appoint my power of attorney as my proxy under the Healthcare Directive Act. When that happens, that person now, when they're making decision regarding your health care, they're wearing the hat of a proxy, not the hat of an attorney appointed. Next slide. So then we go to the power of attorney. The power of attorney is governed by the Power of Attorney Act 2002. We have two types of power of attorney. I'll discuss the second one when I get there. We have the enduring power of attorney. What is an enduring power of attorney? An enduring power of attorney is a power of attorney that once you execute it, once it is signed, it is witnessed by a lawyer, it takes effect, and it is binding until death. Once the person passes away, then the power of attorney is terminated in Saskatchewan. I've had interaction with lawyers in other provinces who say that under their law, it does not terminate at death. But in Saskatchewan, that is the law. Who may grant enduring power of attorney? Anyone 18 years and above, if you have capacity. That's the difference with the healthcare directive. The appointment, you appoint somebody who is 18 years and above. You can appoint them as either your personal attorney or your property attorney or both. Most of the power of attorney that I have prepared, we tend to appoint a power of attorney as both your personal attorney and your property attorney. A personal attorney is somebody who takes care of you. For example, if you go to a home, they're able to access your account to be able to make payments. They can buy your groceries. They can make decisions when it comes to your personal life, your financial life. When it comes to your personal life. When it comes to a property attorney is somebody who takes care of your asset, your land, your houses, your finances. You've given them the right to act like you. I give examples when I meet with my client. I say, when you draft a power of attorney and you appoint someone, that person steps into your shoes. That is the reason why it is advisable to appoint somebody that you trust. They step into your shoes, whether you have mental capacity thereafter or you don't, it becomes effective. The moment you sign it, that's it. Next slide. Limitation to act as attorney, as power of attorney. You cannot appoint a minor. You can't appoint an undischarged bankrupt. You cannot appoint somebody who has a criminal conviction within 10 years of the appointment, unless the person has been pardoned, the person discloses it to you, and you give your consent. So if you appoint somebody who has been convicted, who has disclosed it to you, and you consent, you have to have the consent in writing. The appointment of a power of attorney can be jointly, severally, successively, and you can have a corporate attorney where you have a business. Then you have the contingent appointment, and that's what I said the other time. I said we have two types of power of attorney: enduring and contingent. Contingent power of attorney is actually given in certain circumstances where you want to limit the actions that your attorney can take. For example, you can limit it to, I'm appointing Joe Schmo to be able to access my account at Scotiabank. I'm appointed this person to be able to assist me to sell my house while I'm out of the country. Once you get back, once that transaction is completed, that's it. The power of attorney is terminated effective, because the purpose of the power of attorney, the purpose for the appointment is no longer in place. Or you can specifically say, I'm appointing this person and they are to act upon my incapacity. So what happens is that when you appoint that person, they cannot act, they can't access your finances or sell your house or do anything unless you lose your mental capacity. Once you lose your mental capacity, in those instances, we always encourage that receive two healthcare providers letter stating that you no longer have capacity before that person is able to be appointed. Next slide, please. I think, yeah. So the requirement for a power of attorney, in order for it to be valid, it has to be in writing. It must be dated. It must be signed and witnessed. If you're doing it, if you're preparing it before a lawyer, being witnessed by a lawyer is sufficient. If you are preparing it on your own, you need two people to witness the document for you. The authority of a power of attorney is that the attorney would act honestly, in good faith, in your best interest, and they have to ensure that they care for you there's a duty of care that is imposed upon them. We've had instances where a power of attorney goes ahead, access a bank account, and starts spending money of the maker, the grantor. The public guardian and trustee, I think I attended a webinar some time ago where we're beginning to see instances where the power of attorney steals or gifts money, assets of the grantor to other people. Next slide, please. Okay. Gift. Now, a power of attorney is prohibited from gifting your assets. However, the regulation that they can give to a maximum of $1,000, nothing more. And the power of attorney must provide accounting. They have to provide interim accounting. They're required to provide final accounting. In instances where they don't, of course, if you are not asking for accounting, if you appoint one child, the other children can be asking for accounting. If you appoint a spouse, the children can ask for accounting, and they're required to provide the accounting. You can pay your power of attorney, but it has to be stated in the agreement, in the document appointing them, that they're going to be reimbursed. Not pay them to act for you, but that they will be reimbursed for any expenses that they incur. How is the power of attorney terminated? The power of attorney terminates where you make a new one and then make sure that you inform every organization where you've deposited a copy. You destroy one, make sure that you retrieve all the copies that you've given to any organization, for example, your bank. And that would be the end of my presentation. I know that the next slide shows question, but I would leave it to Della to proceed. Thank you very much. I appreciate your time.
Heidi, you have so much information, and I'm wondering, I know myself, I was writing notes the whole time. Sometimes I was slow on the click. And so it might be that question and answers would be good right now while it's fresh for folks, because there's a lot there. So I'm just going to open that up. If you have a question, please open your mic and ask away.
I have a question about revoking. You mentioned that it should be in writing, and not just oral. Would a video, like if I'm with someone and someone does it with our phone to do a little video, would that be legitimate?
That should be legitimate. And the reason why you can revoke it orally under the statute. But that is not, like I said, it's not my preferable. I don't prefer that. I would prefer that you have it in writing. However, that's a good one. If you have a video, okay, show it recording you as you say, I'm revoking it, that should be sufficient. It is verbal, but it is recorded.
Okay, thank you. And this has been just really, really great. Thank you.
You're welcome.
Thanks, Lynn. Mary Lee?
Thank you for that great presentation. I really enjoyed that. I'm wondering about how is power of attorney, enduring power of attorney, different from executor at death? Like you had mentioned something about preparing for funerals or that sort of thing at death. Thank you.
Thank you very much. That's a very good question. And that is a question that I, at least once or twice a month, I get. A power of attorney is different from an executor. Your executor is the person, the trustee that administers your will. Your will is not effective until you pass away. That is why we say a will is a document that speaks from the grave. The power of an enduring power of attorney is a document prepared while you are alive and you have capacity, and your power of attorney steps into your shoes and does all the things that you can do for you. So your power of attorney can go to the bank, can sell your property, can determine, can do all sorts for you while you are alive. The moment you pass away, the power of attorney is terminated. However, the power of attorney is still required to prepare a final accounting. That's all they do after you pass away, the account. Then, if you have a will, your executor steps into your shoes then and administer the estate.
Thank you so much. Any other questions for Heidi? Well, again, the good news is that I know there was a lot of information, and that we're going to have this as a recording, and you can look at it, and those screens will come up with that information. You can make notes like I did. So helpful, so helpful. I appreciate, just understanding definitions, and what's under the umbrella of those definitions is huge. So I can't thank you enough, Heidi, for sharing your expertise and experience and skill set with us. That's phenomenal. All right, well, next I'm honored to introduce Dr. Kerri Hetherington, another of our board members. Dr. Hetherington is a local family physician who's also a member of the palliative care team at Pioneers Lodge and at the hospital. And so welcome, Kerri.
Thank you, Della. As Della said, I am a family physician and I have an office in town, and then I also see patients in the hospital and in our hospice. I'm really so glad to see all of you attending this talk today on this really important topic. And by attending, I'm just so glad that, that means that hopefully you're at least thinking about this topic. Whether or not you actually have an advanced care plan at this point, you're at least thinking about this topic, and hopefully having some conversations about it with yourself and perhaps your loved ones. So I'm really here to give a practical point of view today on the benefits and importance of advanced care plans from what I see of patients in these situations. I won't talk about power of attorney, but I'm so glad that Heidi made that distinction between power of attorney and advanced care directives, because often in the hospital, we see people and their family member says, well, I'm the power of attorney, but there is that distinction there, that power of attorney doesn't necessarily serve as a proxy unless stated. So as Heidi mentioned as well, every time someone is admitted into the hospital or into a healthcare facility, these questions come up right at admission, really. Healthcare providers are asking the patients, what do you want us to do in the case that your heart were to stop or you were to start breathing, or what kind of treatments do you want us to provide for you? So these questions really do come up every time someone is admitted in the hospital. And time and time again, I see people who haven't discussed these questions or these issues until they're at the hospital and, in a crisis situation. Sometimes they're actually already at the stage where they're not able to speak for themselves, and their loved ones are then having to step in and make these decisions for them. And I just want to point out a really wonderful tool that is available on our website, and Della, I think, is going to bring it up here, called the My Voice Advanced Healthcare Directive Tool or Handbook. So you can see down at the bottom of the page there on our website under supportive care, there is that link. It's a 30-page document, and the first part is really a workbook that reviews what an advanced care plan is. It goes over the benefits, and it gives some really good definitions about the various healthcare directive choices and what they really mean. What is CPR? What is a feeding tube, etc. And it gives a template at the end to actually, make your own healthcare directive. And I find this helpful because the 4 options they have are what we actually use in the hospital in Moose Jaw and in Regina, and it would be similar throughout the province when someone is admitted in the hospital. And just one little note I want to make on CPR, and it does go through this in that document, because when people come to the hospital, I think there's often misconceptions about what CPR really means. And most of us, think, well, it's similar to what we see on TV, where someone may have their chest pumped and receive some shocks, and then they wake up and walk away. When in reality, that's really not, unfortunately, often the case. And in fact, for those really nearing the end of their natural life, CPR is ineffective in over 96% of cases, and can be quite traumatic for people. And only about 1 to 4% of people with any advanced illness will survive CPR and go home. So, just a quick little note or mention on that. So from firsthand experience, when I think of advanced care directives and what I see, how they make a difference for people, it's really not only for the patients having their wishes and values known and respected in their various healthcare experiences, but I really see the huge benefit that it has for their loved ones. I really see how much more calm and peaceful patients and families are during these, what can be quite stressful times, when their wishes are known in advance. The family members are just more calm. They are reassured, knowing that they know what their loved one wants and that they're following their wishes, rather than feeling doubtful about their decisions that they're making on their loved one's behalf. That way they can really just be there with their loved one, acting as their spouse or their child or their sibling, and spending that time rather than having to be kind of guessing at what the decisions are that they're making are actually what their loved one would want. So I have many examples in my head where an advanced care directive has just made things go very smoothly. From the moment that a patient comes into the hospital, we really know what they want and how to proceed, and just how much of a difference it makes for their family. But I think the example that really sticks out in my mind the most is actually an example where there was not an advanced care directive. So I was working in the hospital, and a 92-year-old woman came in, and I will call her Joan. That is obviously not her real name. She was previously quite healthy and very independent, but she came to the hospital. She was quite ill, and she had pneumonia, and her heart was failing. We started her on treatment with antibiotics and medications to treat her heart failure. And as always happens, as soon as she was admitted to hospital, there were discussions had with her regarding her wishes and how she would want to proceed with her health care. And she wished for full treatment. As she said, she really didn't want to die. At that time, she really wasn't open to having kind of more in-depth discussions about what that meant for her, or what kind of treatments she would want, or under which circumstances that living would be acceptable for her. And that's not uncommon. She was quite ill. She was not feeling well at all. She quickly became too sick to really engage in any further meaningful conversation. And then the decisions fell to her children to make on her behalf. The next day or two was really filled with difficult conversations with her family and her healthcare team about the reality of her situation, and what it would really mean for her to possibly be put on a ventilator or undergo CPR. She was quite frail and her illness was quite advanced at this time. We could see this was quite a stressful time for her family. They kept coming back to really the only statement that they knew of her wishes, which was, "I want to live." It was clear that these discussions were not had prior to this. And as her condition continued to deteriorate, she was really at the point where she needed to be put on a ventilator. It was at this time that her family then did decide that they wanted to withdraw treatments and keep her comfortable, as they felt she was suffering and in pain. But really, when I reflect on that, I know that that experience for both Joan and her family could have gone better for everyone had these conversations been had earlier and her family known her wishes and then felt comfortable. They could have really known what living meant to Joan. As I really feel when talking about advanced care directives, they are challenging conversations, as Della mentioned, and they take courage. But the question really isn't simply whether you want to live or die, but really how you want to live. What is acceptable for you, given your values, morals, faith, etc. So again, I just really think it's just so great that everybody is here and thinking about this and having these discussions. And talking with, your family physician, as someone who has perhaps known you for some time, again, is also great. They can answer questions and help you sort through, what the various directives really mean, as sometimes they can be quite confusing. And that's really my perspective. And I think I've gone over time. Sorry about that.
Wonderful. Thank you so much, Kerri. Really appreciate that. And from that doctor's firsthand experience makes such a difference. So thank you so much for sharing. Our next and last presenter is Donna Ackerman. Donna, also a member of our Heartland Hospice Board, and she is on the Supportive Care Committee with myself. And today she shares in memory of Jackie. And so Donna is going to share the family perspective. Donna?
Thank you, Della. I actually have a couple different perspectives to bring to the table today. So advanced care planning, what we learned and what value did we gain from it? Like I said, we had two very uniquely different perspectives to try and answer those questions. The first one is we don't talk about it, and that would be my parents. My dad was a hardworking man from the generation of we don't talk about that stuff. He fought for years to overcome a stage 4 cancer diagnosis and bypass surgery, but his rapid decline into acute dementia triggered a lot of family stress and uncertainty, as Dr. Hetherington alluded to. Nobody knew what his wishes were, no health proxy appointed, so choosing an advocate to make decisions on his behalf was gut-wrenching at times. And we were left with the uncertainty of what he would have wanted done or not wanted done. And it left us with a lot of guilt, questioning after the fact if the right decisions or best decisions were made at the time on his behalf. And then the other part of that was my mother. I saw her lie in an extended care home suffering for years with multiple sclerosis before succumbing to cancer. She was a devoted nurse, mother, and caregiver before finding herself on the other side of being a caregiver. I was quite young when she was diagnosed, but it was difficult to see a vibrant, loving mother's condition deteriorate over the course of her disease. It has helped me think about the many things that I would want or not want to experience if I find myself in a situation that would require long-term care or palliative or hospice care. The number 2 thing that I have learned is we have to talk about it. And that is my sister-in-law, Jackie, of course. She was a passionate, career-minded teacher who was very healthy until quite suddenly she wasn't. At the young age of 50, she was given a palliative care diagnosis, which left some of us in denial and shock for quite some time as to what that actually meant or looked like about her condition and prognosis. However, during the course of her disease, nearly losing her 5 months before her death gave us a second chance to have the hard conversations. But it wasn't easy. There were some barriers to overcome. She had a will that hadn't been updated in nearly 30 years, no power of attorney, no healthcare proxy or directive. We had to have lawyers come to the hospital to deem her of sound mental capacity to be making legal choices after recovering from a critical reaction to chemotherapy drugs. Certainly the last thing that any of us wanted to be doing when she was gravely ill. But we got through it, and once we navigated all of the legal jargon and got everything in place, we got the incredible gift of her having 3 months at home with clarity and decisiveness, where she made known to us what her wishes were, whether we were ready to hear it or not. She gave us the heartbreaking gift of planning her entire funeral, right down to the songs and the readings. She even talked to her friends to ask them to sing or read at her funeral. This was a very profound blessing. I can only imagine how difficult it was for her, yet she was in such a state of peaceful acceptance that it was enviable from where we were sitting and listening to her wishes as our hearts were breaking with the absolute certainty of what that meant. So I guess what the takeaway is from this is, have the hard conversations, get the legal documents signed and in place, make your wishes known, get the right people in place so that your remaining time can be spent loving your families and being at peace with your choices, while removing the burden of the hard choices from your family. Because even though those conversations may be difficult, the weight of those decisions being removed from them is an absolutely incredible gift. Whether you want to or not, it's time to have the conversations, unless you want someone else deciding what they think is best for you. Thank you.
Thank you, Donna, for giving such a diverse representation of that journey. Thank you for your honesty and sharing their stories to help us to understand. I appreciate that deeply. I'm wondering if there's any questions that have come into people's minds that they would like to ask at this time. Yes, Mary Lee?
I have another question, and this would be for Idy. So I was wondering, can you tell me about a proxy and their ability to do a medically assisted death? Because I know that you can do that if you have a terminal illness, but you have to be of sound mind. So if somebody is not of sound mind, but you know that there's an imminent death, is that something the proxy can undertake? Thank you.
Thank you, Mary Lee. Unfortunately, that area is new in Saskatchewan. It is something that we're still trying to figure out how to deal with it. I think I know of one person who has had that done, where they appoint a proxy to assist with that. And I'm not sure that your healthcare provider would, unless the law is clear on their side, I probably would leave that to Kerri. If Kerri has seen anything like that, I don't know. And I don't want to give you a wrong answer. It's something that needs to be researched. But I know of one person who's done that, but I did it with caution and saying it probably might not be binding on your healthcare provider.
That's right, ID. So currently, as the law stands, Mary Lee, regarding medical assistance in dying, as the law is today, the person themselves has to be of sound mind to give consent. There are a few things that the federal government is looking at, and that is one of them, whether you can write kind of an advanced care directive for medical assistance in dying, but as it stands today, you cannot.
Thank you so much for the question and the honest answers. Is there any other questions from the gallery?
I have kind of more of a comment. Donna, first of all, I'm so sorry for all your losses. That's so sad. And you've handled it so beautifully. And thank you for all your info. I have 2 grown children. They don't live in the province. And we have just updated all our things. And we're just reminding them they have to do that. We don't know where their banks are. All those things that are just terrible when this stuff happens close to home, never mind far away. So number one, convincing somebody in their early 30s that, hey, you could have a problem. That's really hard, but we've been trying to have those. And also relationships change, and no matter what our ages are. Do you want the person you said 5 years ago in your will to get your money? Is that what you want? Like, that's the thing I think maybe sometimes people don't think about if they have done a will but haven't updated. Anyway, just a couple comments of things we've faced with our own kidlings. Thanks.
Thank you. An important perspective. Heidi?
Thank you. With regard to your will, the rule of thumb is this. It is always advisable to review your will every 5 years. If nothing significant has happened, review your will every 5 years so that you bring it up to date. With your healthcare directive and your power of attorney, it is important to at least take a look at it every maybe 2 years, or if there is a diagnosis. If there is a diagnosis and you still have mental capacity, it is very important. And I tell people this, I'm a lawyer, I'm in the business of making money, yes. However, when it comes to healthcare directive, power of attorney, and wills, even if you can't afford it, get a lawyer, go for a consult with a lawyer to advise you what needs to be in your will and so on and so forth. I know that banks have this power of attorney. We have issues with power of attorney coming from the banks. I know that you can buy your will packet from Staples. It's complicated. If you have a very simple simple asset, fine. But speak with a lawyer and get some answers. Then you can go ahead and draft it yourself. But get advice and talk about it. It's quite advisable.
Thank you, Heidi. Good advice. And as a person who works in the funeral home profession, we've certainly seen the absolute need and the value of having things in order. It is such a challenge for family at that time to be making decisions at a time when they're almost incapacitated emotionally and mentally for making big decisions. So I just think at every level, these conversations are absolutely vital. Absolutely vital. And I had the value of walking with mom and dad frontline. And my husband had said, man, your parents did it all the right way, right? It was all on the table. There was no questions that we didn't know the answers for. And so I just was really appreciative for the courage they had to talk about the reality of death, because it's a reality. And so how to face it, and how for all of us to face it in gentle, courageous ways. Any other questions? Well, I just can't thank our team enough for the mind and the heart that you put into this presentation. Your expertise really shone here. So thank you so much for that. And I want to thank each of you for showing up today for this conversation. And I wanted to share with you a screen that just shows our website so that if you want to look up any information, then it is Heartland Hospice Moose Jaw that you'll find it. Heartland Hospice mj.ca is our website, and there's lots of information on there. And that's where Dr. Kerri mentioned that advanced care handbook, that is under the supportive care tab right here. You see the supportive care. That's the tab. You would just open that, and there's a number of different grief and bereavement related and all types of supportive care information. If you have any questions, any further questions, please don't hesitate to email. We have this general email address, and it will be forwarded to whatever specific person your question would be best answered by. So admin@heartlandhospicemj.ca. So love to have you check that out. It's a great source of information. And so I don't think, we were hoping that our chairperson, Angela Sarita, would be able to join us, but she was having to do some work this morning. So I'm going to say a final thank you, bid you farewell with this final thought. Be brave enough to start a conversation that matters. And so here's to courage. Thank you, and peace to your weekend, everyone.